guys, it's Kathy. I hope you're doing well. So we're going to spend most of our time in Colorado today. I like this judge. She's like no nonsense. She doesn't put up with much. So she's a good one to watch. Here we go.
Docket. Court calls number 26 on the docket, People versus Quincy Johnson, 25 CR 3463. Entries.
Holly McDonald for the people.
And Emily Boehm on behalf of Mr. Johnson. He is present next to me at the podium appearing in custody.
Is it Boehm?
Yes.
All right, we are set for our first arraignment in this matter. What do we need to address?
Your Honor, we are asking for a continuation of the arraignment. I have a forensic social worker that I am working with to prepare a mitigation report. There are a significant amount of collateral documents, some of which we have, some of which we are waiting on. So I did let Ms. McDonald know that our request would be a continued arraignment, and she, I don't believe, is objecting to that. In addition to that, we are asking to address the issue of bond today.
And I also just want to jump ahead for a minute. Mr. Johnson was 18 at the time of the charged offenses, correct?
He was.
Okay, so we don't need to do a reverse transfer to address reverse transfer at all, right?
That's correct.
Okay, all right. People, can you address bond today?
Yes, Your Honor. We are in VRA compliance.
All right.
Your Honor, would the court like me to start there
Yes,
with
please.
bond? May I approach with a release plan that was put together by my forensic social worker? I did provide them a copy.
You may.
Thank you.
All right, you may begin.
Thank you, Your Honor. So Mr. Johnson was an out-of-county advisement, and I think that the pretrial bond report that was filed in this case is lacking information that would be helpful to the court's determination in setting a bond, and that was the information that was available to the initial court when they set the bond in this case. I did provide a release plan to the court, which I think addresses a number of things that the bond statute asks the court to consider. Mr. Johnson was accepted into sober living at 2 locations, Onaneo and Stride. I do have letters from both of those locations indicating he was accepted and would be able to go to a bed there, and I can file those as exhibits to this hearing today. In terms of a release plan in either of those situations, Mr. Johnson would be released directly from the jail to staff at one of those sober living programs. He would have a strict 9 p.m. curfew. He would be required to take classes weekly. And certainly he is willing to wear a GPS monitor and comply with any other conditions of bond that the court feels may be appropriate. In addition, at both of those locations, there is staff on hand to monitor Mr. Johnson on a continuing basis. If and when sober living said it was appropriate, he also does have job options available to him as well. One of those job options would be working with his aunt. Her name is Roxanne Webster. She is present in the courtroom today. She is a manager at a location called Copper Nut and Bolt, and Mr. Johnson would have a job opportunity there 40 hours a week. I think the typical hours are 7 a.m. through 4 p.m. Monday through Friday, although the job often involves overtime. As the court can see from the release plan that was provided to the court, Mr. Johnson does have a solid support system, many of which are present behind me in the courtroom. These individuals include Len Chacon, who works with individuals in the jail and would be able to provide peer support. He is here today. The defense forensic social worker, Ms. Tenuta, who is also present today. His aunt, who is present behind me, his sister, who is present behind me, and in addition to that, Miss Woods, who is the restorative justice coordinator at Smoky Hills High, who is also present here behind me in the courtroom today. His sister is 24 years old. She stages homes for real estate agents and also works for a makeup company. If and when he were to transition from sober living to a different living environment. He would be going to live with his sister in a home that she recently purchased. His sister has no criminal history, is employed, and is positively involved in the community. I would note for the court that any of those individuals I referenced, again, are present here in the courtroom today and would be happy to answer any of the court's questions or address any of the court's concern. He does have additional ties to the community as well. His grandparents on both sides do live in the area along with his stepdad. Mr. Johnson has been thinking about his future. He wants to have a career that involves working on cars. He was supposed to go to trade school starting in August for collision repair, but unfortunately was arrested before he could make that happen. He, as I mentioned, is willing to comply with any conditions of bond. His plan is to go work and come home. He will do GPS, sobriety monitoring, whatever the court thinks is appropriate. I would also just draw the court's attention to Mr. Johnson's young age. He turned 21 recently while he was in custody, and specifically the considerations for the court in terms of the bond statute, namely 164103. As someone who recently graduated from high school and is still becoming a young adult, he clearly does not have the means to post $1 million cash-only bond, which is, in this case, for all intents and purposes, a no bond for him, as evidenced by the fact that the case has been pending for over 6 months and he has not been able to post that bond, even with the assistance of family. The other thing in terms of the bond statute and those considerations is the purpose in ensuring one comes to court. This case was initially filed in Arapahoe as a 2023 case and was ultimately dismissed there due to a lack of evidence. Mr. Johnson has been in the metro area the entire time. He attended every single court date in that Arapahoe case, and he was on GPS and maintained compliance with that GPS court order in that Arapahoe case, and again, remained in the metro area after it was dismissed. The other primary issue is that he, while in jail because of the bond amount, is on some of the strictest protocols. He is in his cell 22 hours a day and out 2 hours a day. Sometimes he indicated that that is more like 23 and 1. Certainly this has been challenging for Mr. Johnson as it leads to isolation for hours upon hours every single day for months on end, which takes a toll in terms of anyone's mental health. In terms of the other considerations for the court and ensuring community safety, I think the release plan provided to the court is significant because it's comprehensive, but I think it also demonstrates Mr. Johnson's own initiative regarding a plan for his future. He has engaged with the MAT program while he's been in custody. He has engaged with individuals who work with the jail to provide resources and peer support. And certainly he has a number of individuals here in this courtroom who are pro-social, positive role models for him. But at this point, Your Honor, the most he would be able to afford, he believes, is somewhere in the vicinity of $200,000 to $300,000 cash or surety. What I can tell the court is any reduction would be significant in terms of his ability to be in a different pod or status level in the jail so that he is not in confinement for the vast majority of the day. And that is what I have for the court, unless the court has specific questions for me or the other individuals who are here to support him.
Thank you. For the people.
Yes, Your Honor. The people object to any change in bond. The people find the bond as is set as appropriate. In looking at the case and specifically Mr. Johnson's case, these are very violent cases. They are very concerning cases. If you look at Mr. Johnson's, the arrest warrant that went through, he is charged with 2 counts of multiple counts, but specifically with 2 incidences, both taking place at 18772 East Union Place within the matter of days of each other. And at the time he was 18, and the first time that this house was fired upon on May 3rd, 2023, there were 5 individuals in that home, a mother, her daughter, another child, and then her 2 grandchildren. At the time that Mr. Johnson fired on this home, there was a 4-year-old and a 5-year-old that had to dodge bullets and hide. And in looking at the report, it lists the damages that was done. And if I can just have a moment. On the May 3rd incident, one bullet entered the east side of the kitchen living room window. That bullet traveled through the kitchen into a bedroom on the north side of the residence. One bullet entered the dining room under the window and impacted a white duck grill. One bullet projectile entered the upstairs master bedroom on the southeast side of the residence. This bullet traveled to the west through the bedroom and through the walls separating the bedroom and the bathroom. And it ended up striking and breaking a tile in the bathroom. One bullet entered the bedroom on the west side of the bathroom, where it entered a mattress in that bedroom. When that incident failed to, I guess, hurt anyone, kill anyone, failed to send the appropriate message. 4 days later, Mr. Johnson went back to the bedroom, or back to that house, and fired on that house once more. Again, in the report, there's 2 suspected bullet projectiles through the outer window of the kitchen, although they did not break the inner window. 2 suspected bullet holes along the north wall of the dining room. 1 suspected bullet projectile hole entered the south lower side of the door. 3 suspected bullet holes are on the south wall of the upstairs bedroom. The family indicated that 1 was from the previous incident. 1 suspected bullet hole in the window along the east wall that appeared to travel through the window blinds, curtains before striking the south wall of a bedroom. That was the interior. The exterior. 2 suspected bullet holes to the rear exterior of the resident. 2 suspected bullet holes in the window near the northeast corner. 1 suspected bullet hole in the window that led through the kitchen area. 1 suspected bullet hole to the lower south portion of the back door. 2 suspected bullet holes in the window of the back door in the frame. 1 suspected bullet hole between the windows that they were not able to retrieve. The family in this matter lived through this, Mr. Johnson's actions, within 4 days. The amount of bullets that were fired is astounding. The people have grave concerns about the community safety, grave concerns about Mr. Johnson's ability to remain law-abiding. And quite frankly, the people was given this today in court. The people have not had a time to review or follow up on any of these sober living. I will note that this is the first time I'm hearing that sobriety is an issue for Mr. Johnson. As for stride, in looking at this, he will have a strict 9 p.m. curfew. However, Mr. Johnson is an adult. He does not have to remain at a sober living. They cannot hold him. There's nothing about this being a lockdown facility, nothing about his ability to leave when he wants to. I understand that he has community and family support, but he had that family support when this occurred. And he still committed these crimes. This community safety plan or release does not indicate which sober living he will be attending. And again, the people would have appreciated a little bit more information that beforehand so that they could have followed up on these community safety, this community safety plan. Additionally, I would note the victims do object. Miss Wright, the mother, whose home was shot twice in the 2 incidences involving Mr. Johnson, but a 3rd time in September later that year, says she very much objects to the bond reduced. The defendant shot her house twice, and she and her family had to duck and hide from bullets. And that we can imagine how scary that was. Another victim that was in the home at the time indicates that she objects to the bond being lowered. She's scared if he was to be out. She believed people were following her, and she's just generally scared of the defendant. Reduction in this bond in this case is not appropriate. Mr. Johnson has shown a disregard for the safety of the community, the safety for the people of Denver, and particularly the safety of this victim, where he went back twice within a matter of days and fired multiple bullets into that home, given that the people would object to any change.
The court has considered the information provided by counsel and the release plan. The court has also reviewed the affidavit and application for arrest warrant for Mr. Johnson. Certainly, while these remain just allegations, the court does note that Mr. Johnson is facing 55 charges. In this case, the court also has considered the significant public safety issues that exist regarding Mr. Johnson's alleged activities. And frankly, the bond does appear appropriately set at this time. So the court is going to deny the request to reduce bond. Bond will remain at $1 million cash only. The court does, again, have really overwhelming community safety concerns. All right.
I think we just need a next.
No, we don't need a next. We're good. We're good. All right, so that was a recap of one of the highlight videos from the week. All right. Let's go to a different judge.
Did the court receive the letters of support I emailed this morning?
No.
No? Okay.
But,
I will address them in my record then.
okay.
I emailed them to the 4G courtroom.
Sure. Hold on one second.
You're doing
What number is this?
16 and 17.
6, 7.
Hey, I'm calling case number 25 CR 1698 and 23 CR 5791. Appearances?
I'll be right back. I'm so
Kate
sorry.
Horton for the people on behalf of Dan Cohen.
Nathan Hall on behalf of Mr. Garcia. He appears in custody in person to my left. Good afternoon, Your Honor.
I will get those additional letters in a minute, but in the meantime, I've had the opportunity to review the PSI. And do you have any corrections?
No changes or corrections on behalf of Mr. Garcia. Thank you.
On behalf of people?
No, Your Honor, thank you.
All right. Argument as to sentencing from the people.
Your Honor, this is Mr. Cohen's case. I can tell the court that ultimately his request is going to be for 10 years in the 25 CR case with a consecutive 4 years in the 23 CR case. I don't see Ms. Dooling present virtually. I thought she might be here based on the notes. If she's in the lobby, I would ask that we let her in, but I have not seen her.
This was set for
8:30, I think, Your Honor.
8:30?
She may not be present. I just wanted to make sure that we had her in if she was. Your Honor, Mr. Cohen's notes on the sentencing say that Mr. Garcia was convicted of the F4 burglary here with an aggravated sentencing range of 4 to 12 years in the Department of Corrections.
and no waiver of the 2 prior felony rule, which means it is a mandatory prison sentence. This new conviction acts as a revocation in the probation on his 23 CR 5791 case, where he's facing between 1 and 6 years in the Department of Corrections. Mr. Garcia has 4 prior felony convictions, and he was on probation in 2 of those cases on the date of offense. He's a maximum risk LSI according to the LSI instrument and has twice been unsuccessfully discharged from treatment. This case has him dangerously eluding police when they attempt initial contact, including driving up onto a sidewalk and crashing into property. He and his co-defendant then abandon the vehicle and flee on foot, ultimately manipulating their way into the victim's apartment under false pretenses, where he and the co-defendant then will not allow the victim to leave. And Mr. Garcia eventually tried to escape out the back window when the police finally arrived. This was a terrifying event for the victim to go through, and the kind of crime that does extensive damage to her and to the community as a whole. Mr. Garcia's criminal history is extensive, recent, and escalating, and the only real way to ensure community safety and to adequately address the shocking facts of this case is to sentence Mr. Garcia to a lengthy Department of Corrections sentence. As I said, Your Honor, Mr. Cohen is requesting 10 years in the 25 CR case and a consecutive 4 years in the 23 CR case. Mr. Cohen did also file a request for restitution that requests $1,207.25 in restitution. It looks like he did contact Mr. Hall about that, but I'm not sure if there was a consensus on that.
Anything else?
No, Your Honor, thank you.
All right. Mr. Hall?
Thank you, Your Honor. Mr. Garcia, well, first I'll say I agree with Ms. Horton in terms of the ranges here, 4 to 12, 1 to 6. Mr. Garcia is asking that the court sentence him to 4 years of DOC and resentence in the 23 CR matter to 1 year of DOC concurrent. Mr. Garcia takes full responsibility for his involvement in this case and his struggles or frankly lack of compliance on probation. I think it's important to note that as the court can see from the PSI, Mr. Garcia took full accountability in his statement. He acknowledged Ms. Dooling and how his actions affected her. He also notes that he's a drug addict and committed this offense during the course of his daily struggle with drugs. And I mention that because I think it's important when we have someone who not only takes full accountability for what they did and their involvement in how they impacted the victim's life, but kind of has the insight into why this happened and where things went wrong. Obviously, though, Mr. Garcia's substance use is not an excuse. I do think that gives valuable insight, though, for the court into how we got here. While getting clean is rarely a linear path for people like Mr. Garcia, I think taking that step, as he's already done, of acknowledging that he has a problem and needs help, is a critical kind of move in the right direction. He notes that he knows what it takes and is willing to do what is necessary to be a better person and to get clean. And that's noted in his handwritten statement on the last page of the PSI. As the court can see, and as Ms. Horton mentioned, Mr. Garcia is a maximum LSI. Alcohol and marijuana were introduced to him at age 11. By 15, cocaine, methamphetamine by 16. Like many other Americans, he became addicted to prescription opiates as a teen. And when those ran out, he resorted to heroin on the street. Those addictions, as the court can see, followed Mr. Garcia from his preteen life into his teenage years and into adulthood. Mr. Garcia reported using 2 grams of methamphetamine and 2 grams of fentanyl daily and being under the influence of those same drugs when he committed this offense. Mr. Garcia recognizes that he's before the court on sentencing for his 6th felony and his first sentence to prison. He has been sentenced to probation, like Ms. Horton mentioned, and he's been unsuccessful in the past. He understands that the mistakes he's made and the steps he's taken affirmatively to get here are how we reached the resolution that's before the court, this agreement to prison. And I think it's critical to understand that a prison sentence doesn't necessarily effectuate society's goals of rehabilitating Mr. Garcia or giving him the treatment he needs. What it does is it isolates him from society. Despite Mr. Garcia's struggles, he has the support of loving family members, two of which are present today, his mother and grandmother. I do believe they want to make brief statements to the court, if the court would entertain that. And other members of the community. I apologize to the court for emailing those letters of support so late. But what we have here are community members, cousins, family members, siblings, who all share the trend of Mr. Garcia being introduced to substances at a young age, being at one point, a young man, a loving friend and family member who lost sight of his goals in favor of his addiction. He's described as a loving father who has 4 young kids that need him. These letters show the trend of believing that Mr. Garcia, despite his struggles, has what it takes to seek help, take responsibility, and work towards recovery. Most importantly, these letters all show the trend of a community that will have Mr. Garcia's back throughout whatever comes next in his life. Mr. Garcia is clearly at a turning point here, and things are not trending in the right direction. He acknowledges that. And as the court knows, he's been in custody on these cases for quite some time, but he has used that time wisely to reflect on what he needs to be successful and the changes that he needs to make in his life. Mr. Garcia on his own has applied and got accepted into Stride Sober Living and has been accepted recently into the Other Side Academy. He applied for those opportunities knowing full well that he was receiving a DOC sentence in these cases. I think that's relevant because that is another step in the direction of acknowledging his needs for treatment. I think there's hope here, and I have confirmed with 2 members of the Other Side Academy that they're willing to hold his acceptance to that programming and that treatment in abeyance for a maximum of 1 year. And so theoretically, if given a sentence to 4 years in this case, he could be picked up directly from DOC by the Other Side Academy and engage in that treatment the same day. Or at the worst, be in a position to reapply and still be on their radar. We're talking an amount of days if the court were to sentence to 4 years. Again, as I've mentioned, obviously these cases involve a DOC sentence. What Mr. Garcia is asking the court to consider, though, is what comes next. Because we all know that whether it's a sentence to 4 years or 12 years, Mr. Garcia is going to be back in the community. And so,
But first, think about what comes next for the victims before you think about what comes next after he gets out of jail 4 years from now.
So we either can sentence him today according to a theory of punishment that isolates from society and says he's not fit for society, or we can sentence in a way that complies with punishment goals of rehabilitating offenders. And as the court knows, that is one of the provisions of 18-1-102.5 to promote rehabilitation by encouraging cooperation and participation for convicted offenders in correctional programming or their treatment needs. Mr. Garcia has the support around him and the tools at his disposal to reintegrate into society with help. Not everyone who goes to prison has that set up. Again, as I mentioned, Stride Sober Living, Other Side Academy. I think a sentence to 4 years satisfies the district attorney's goals of punishment. It also satisfies the court's goals of 18-1-102.5 subsection A. But it also gives him the opportunity to get the treatment he so clearly and so desperately needs. And so for all of those reasons, Your Honor, unless there are questions, I'm asking that the court sentence Mr. Garcia to 4 years in the 16 matter and 1 year concurrent DOC in the 17 matter. And I do have his mother and grandmother who have brief statements if the court would entertain them.
I would like to hear from them, but how much pre-sentence credit does he have?
In the 16 matter, so 25 CR, 320 days. And in the 17 matter, 23 CR, 381 days. Thank you.
All right.
Good afternoon, Your Honor. My name is Frances Martinez. I am the proud mother of Jesus Garcia, standing to my left. Thank you for allowing me this opportunity to speak on behalf of my son. As a child, he was a very curious about the world and had a mind for writing and was a whiz at math. We've always had a loving relationship, and I've missed him. I've spent my life working to provide and lead him well. I tried to keep him safe, but the world is a very big place, and my boy got lost. His substance abuse issues have kept us apart. I wish I could have done more, but I am so glad that he is alive today and has the opportunity to rebuild his life. As you consider his sentencing today, I ask that you offer us some hope. He will be back with his loved ones sooner than later. Thank you for your wisdom and your ruling today. Thank you, Your Honor.
Thank you.
Thank you for giving us this opportunity to speak. My name's Veronica. I'm Jesus's grandmother. My daughter and I raised him since birth. We've lost so many family members through this scourge of addictions, not just in our family, but throughout the community. Jesus had a good job before he got injured and got stuck with opiates. And then from there, it went downhill. Jesus's father spent most of his life on the streets or in prison. Jesus did not have the benefit of his father's support. Thankfully, since then, his father has cleaned up his life and is in a good position to help his son, Jesus, when he is released. As mothers, it's been hard on us to lose our children and raise the children of those who have been wiped out by these addictions. And it's just been a harsh environment. Please consider if he is allowed to do a shorter sentence and do rehabilitation, that he will be able to come back to us, and I will hang on to him. I know he'll have a good life from then because he was having a great life before the addictions. We all were. Just, Your Honor, we need him. His children need him. I don't want them to grow up anymore without their father. We're doing the best we can, but we are not men. His kids need a dad. Thank you so much. Can I hug my grandson?
That's not really my call, but no.
I love you, sis.
Mr. Garcia, you're not required to say anything, but if there's anything that you'd like me to hear in support of your request by your attorney for sentencing, this is the time for you to tell me.
Yeah, thank you, Your Honor. I'd just like to say that I'm sorry for my actions. I know I endangered the whole community that day with my reckless behavior, and I'm just so sorry for that. I've let a lot of people down, my family, myself. Just being here this 11 months, I mean, I've seen people come and go once, twice, 3 times, and just what that's made me realize is there's no shortcuts in life. So I know that, sorry. I know my journey is a long one, and starts today, and just appreciate your time, Your Honor. Thank you.
Thank you. Hold on one second.
And Your Honor, I forgot to mention, but in speaking with Mr. Garcia, he is in agreement to the restitution amount that's requested, the $1,207.25.
Okay.
So there's no objection to that amount.
All right. So the court has reviewed the pre-sentence investigation report as well as the underlying complaint in this case, and heard the facts of the case and the arguments of counsel. I've just reviewed the statements provided by counsel. Some of those statements also include the ones from Mr. Garcia's mother and grandmother as well back in 2025. And I've also heard their statements today. As Mr. Hall mentioned, there are a number of facts in the statute that the court has to consider in determining what an appropriate sentence for a defendant is. Now, from my review of this case, and it looks like from the letters that are provided that a lot of the arguments that are being made are also the fact that your children need you, and that you have 4 children. It looks like the oldest one is 13. I will tell you that my concern is this is your 6th felony,
Yes, ma'am.
and this would be the first time that you're being sent to the Department of Corrections, right?
Yes, ma'am.
And, even though obviously you had children for at least the last 13 years, it didn't deter you from crime, right?
You're right.
And so it doesn't feel as persuasive to me to hear that, especially in the letters, that you either are a good father or you want to be a good father when given the opportunity, you didn't take it. And one of the telling things to me when I look through the PSI and I listen to and I read the letters that were provided is that you have women around you who are supporting you, who are trying to do everything within their power to do right by you so that you can do right by them and to your children. And at the end of the day, what I'm hearing is they need men in their lives, right?
Ma'am.
And when you were given the opportunity to be in their lives, instead of taking it and kind of like running with it, you didn't. When I look at the PSI also, you have multiple probation revocations. It looks like you were previously given an opportunity to be on probation. Some of those probations were revoked unsuccessfully. And I'm happy to hear now that you're accepting responsibility and that you're ready to move forward, recognizing that you've had significant substance issues. And I certainly am considering that as well, because some of that is, that's something that plagues everyone. It doesn't matter what, your socioeconomic status is, whether or not you're a parent or not. It's something that everyone can deal with. But I also have to consider punishment for you. In making that decision. And so in looking at everything that's provided, including the sentences, I'm going to sentence you to 8 years in the Department of Corrections, okay? And I know 8 years seems a lot, and people look and think about the Department of Corrections as if it's the worst thing in the world, but people go into the Department of Corrections and they are given an opportunity to learn, to clean up, to get their lives together. It doesn't mean that you can't, see your children. It doesn't mean that you can't learn anything and do things that you need to do, but you need to take that opportunity to clean yourself up and think about how you can move forward in life. Being on the streets And whatever life you've had, it's not working for you.
Yeah.
And so you need a reset. And this is going to be an opportunity for you to reset, okay?
Okay.
But what I'm going to do is I'm going to sentence you to 8 years in 25 CR 1698. And then I'm going to, with respect to, 23 CR 5791, I'm going to actually make it concurrent, okay?
Thank you.
But I'm going to sentence you to, well, it's going to be a 4-year sentence, but it's going to be concurrent to the 8-year sentence that you're serving in 25, all
Okay.
right? I'm going to give you credit for the time that you served. In 25 CR 1698, I'm going to give you 320 days of pre-sentence confinement credit. And in is it 23 CR 5791, is that 381 days?
Yes, Your Honor.
Okay, 381 days in pre-sentence confinement credit for that as well. The court is also going to order that $1,207.25. Oh, wait, hold on, before I do that. I'm also going to order 3 years of mandatory parole whenever you're released from DLC, okay?
Okay, thank you.
I'm ordering that you pay restitution in the amount of $1,207 to be paid by you for any losses suffered as a result of your conduct. And that restitution is going to be, you're going to be responsible for it even once you're out of the Department of Corrections, okay?
Mm-hmm.
All right. I think that's it. Is there anything else you want me to address, Mr. Hall?
No, thank you, Your Honor.
On behalf of the people, Ms. Horton?
No, Your Honor, thank you.
Good luck to you, Mr. Garcia. Who is this?
This is Robinson Marcus. Proceed.
Oh, Marcus Robinson.
Hi, Aaron.
Good afternoon, Mr. Robinson. I have, oh, wait, hold on a second.
Oh.
I'm calling 24 CR 5771 Marcus Robinson appearances.
Your Honor, Jennifer Sisk for the people.
Go ahead.
Yes,
Identify yourself.
Marcus Robinson.
Okay, so I've looked through this case and it looks like, I see that you've provided a number of different, letters to the court. Back in December, it looks like there was a conflict with your, investigator, so you don't have an investigator.
No, there has been one appointed, but I never received the paperwork. I saw that it was in the ROA that they sent to me after the letters to Court of Appeals. So they sent me that, but I've spoken with him, but there's not been a lot of progress made, and he's not always the easiest person to get a hold of, similar to Benson, my ADC in Adams. So it's
Mr.
just- it's
Benson is
just
not your
been-
ADC counsel. I want to make that clear.
He is in Adams County.
Okay, but he's not here, right?
No, not here.
Okay, so,
And Your Honor,
it looks, oh, go ahead.
I think, and I gave the paperwork to Mr. Robinson. I think
Yes.
we are resolving this case today with a plea.
Yeah, oh,
confirm it?
yes, I did. I signed the, yeah,
Should
yeah.
have started with that. All right.
Well, I thought you were trying to address the letters.
Did you
For some reason.
sign the paperwork or are you?
Yes, there was already signed. Did you receive your copy?
Do you?
I did not. If I can get it from Mr. Robinson, I can bring it to the court. We've
Okay.
just done it in court this morning.
Oh, did she, I thought you made a copy of it. Oh,
Did you upload it already?
Your Honor, I did not. Mr. Robinson just signed it. I can give this to the court, and then if I can have it back.
He can't. He can't shut up. He's not going to shut up the entire freaking hearing. He has words that he wants to say. And every time the judge asks him a question, he somehow navigates the conversation away from her question to what he wants to tell us. So we're just going to sit here and listen to him.
I can
Yeah,
upload it
of
this
course.
afternoon, if I may approach.
Just find it from the stack that I have here, people who don't sweep up this stuff.
Yes.
Thank you. All right, Mr. Robinson?
Yes. I mean, I was advised, some of the things I didn't feel that they really applied, but I did initial them anyway.
Yeah.
Is there still some other things pertaining to the rest of the plea agreement?
Well, I have to go over all of the I have to go over it all with you, and I need to make sure that you understand it all. So I know that there's some parts of the paperwork that don't apply to you, but I'll go over the ones that do apply to make sure that you understand what your rights are, okay?
Okay.
All right.
Thank you.
But let me look at it really quickly. All right, Mr. Robinson, I have in front of me paperwork that indicates that you would like to enter into a plea of attempted criminal attempt to commit second-degree kidnapping, which is a Class 5 felony, and that sentencing will be open to the court, but shall be run concurrently with Adams County cases 25 CR 1141, 25 CR 1601, and
Okay, so I don't know what the other cases are. I don't. It doesn't matter. Wait till you hear what he pleads to. Someone who pleads to what he pleads to should not be as cocky about things owed to him. I just shouldn't be. But he truly feels that his investigator for his case not contacting him enough is a much bigger crime than what he pleads to. I'm just gonna play. I'm gonna shut up. I'm gonna press play before I get mad.
Jefferson County case 25M 319. That you, in order to agree to concurrent sentencing, that you agree to plead guilty to a Class 1 misdemeanor, third-degree DV assault in Jefferson County, 23M 319. In Adams County to 25 CR 1141 to attempted robbery, a Class 5 felony, as well as 25 CR 1601 in Adams County to attempted bribery, a Class 5 felony. If a Department of Correction sentence is imposed in Adams County 25 CR 1141 or Adams County 25 CR 1601.
So those were all from completely different counties. He has this case of robbery in this county, this case of assault in this county. They are not the same crime. They're not the same victim. They're in completely different counties, unless he had a spree and then he went to Adams County, and with this victim he did this, and then he drove this victim to Arapahoe and he did that, and then he drove him to Jefferson and then he did that. Then maybe it's the same crime spree, but it's not. All of those, domestic violence, attempted bribery, assault, are 3 different counties. Therefore, they have to be 3 different crimes. Maybe the same victim, but not the same spree, not the same incident. Okay? None of that you just heard is what he's here for. He's here for crimes that he did in this county, which I believe is Denver. I believe. But I'm not 100% sure. But it's just, I do know it's not one of those counties. Okay? So, here we go. See, I'm not getting mad. I'm just playing a court video. That's all I'm doing.
Adams County will cap the sentences at 4 years. Is that correct?
Yes, that's what's in.
Excuse me?
Yes.
All right. And then failure by you to enter into pleas in any one of the above listed cases will nullify the agreement to concurrent sentences.
Yeah, so my understanding was that I had to, the previous agreement was a little different than that, at least in its reading. So it's my point to just go to my other court dates to address that with those counties.
Yeah, you'll go to those, but if you don't plead in those, then the agreement to concurrent sentencing will go away. All right?
Yes.
Okay. Is that how you want to move forward today?
Yes, ma'am.
Okay. Did you have enough time to think about it and read the paperwork to understand what it is that you're pleading to?
That hasn't been much of the problem. It's just been communication with the other parties, really.
Okay, with the district attorney's office?
Yes.
But you
All
had
the way around, really, because.
Yeah. Yeah, it happens like that sometimes when you're pro se and in custody. But do you feel like you had enough time to review everything and you understand what's going on?
I understand what I just signed, and I'm going to make the argument with the other counties about the differences that is in the plea agreement because it wasn't as such when it was originally presented to me.
Okay.
That was the question that I had with DA president right now. I believe that it was proposed to me that it was going to be as the original, but I don't have a lot of problems with the changes. I just wanted to know, like I did then, about the ramifications of each one per the charges.
Okay,
That's all.
so I don't have any previous agreement that you had or may have
I
entered
understand.
into it or negotiated. What I have is this paperwork.
Yes.
And so if you can go to Adams County or Jefferson County and
Yes.
negotiate whatever you want,
I know.
but this plea is what I have control over, and this is the plea that I would be accepting today if we go through your rights and you understand what it is and you understand what the impact of that is going to be on your rights, okay?
Yes.
All right. Please state your full name for the record.
Marcus Sheldon Robinson.
Okay. And you're the defendant charged in this case.
Yes.
How old are you?
52.
And how far did you get in school?
12.
12th grade?
Yes.
Okay. And do you read, speak, and understand the English language?
Yeah.
Okay. Are you thinking clearly today?
Yes.
Have you consumed any prescription medication, pills, drugs, alcohol, or marijuana in the last 24 hours?
No.
Are you suffering from any mental or emotional condition that would make it difficult for you to understand what is taking place here today?
No.
Are you a veteran?
No.
Now, you are pleading in this case to, and count 3, which is criminal attempt to commit second-degree kidnapping. That plea is that you, on September 23rd,
You know how sometimes they call it kidnapping when a couple are in a relationship and they get into a domestic violence type fight and, you know, she like locks him in the room or something like that. That happens during like a domestic violence type argument with your partner. Nope. That's not what this is. This is kidnapping. For real, the real deal, the thing.
of 2024 in the city and county of Denver, unlawfully and feloniously, knowingly, engaged in conduct constituting a substantial step towards the commission of second-degree kidnapping, by attempting to seize and carry Raven J. Porterfield and Jody C. Kennedy from one place to another without the consent of the victim and without lawful justification, and that such movement increased the risk of harm to the victim in violation of the statute. Do you understand that?
Yeah.
Okay. And having heard that, what is your plea with respect to that count, guilty or not guilty?
Guilty.
Okay. Before I can accept your plea of guilty, I need to make sure that you understand your rights and the effect of this plea on those rights, okay?
Yeah.
You have the right to be represented by an attorney at all stages of a criminal proceeding, not just this one proceeding today, but all proceedings that may be held in this case up to and including a trial. If you are indigent and cannot afford an attorney, one would be appointed to you at no cost to you. You have a right to a speedy and a public trial, which must be held within 6 months after you enter a plea of not guilty. You have the right to have the charges proven against you before you can be convicted of them. At any trial, you would be presumed innocent and you would not have to prove anything. The district attorney would have to prove your guilt by proving all the elements of the charges beyond a reasonable doubt to all 12 jurors because any jury verdict must be unanimous. At trial, you would have the right to testify, you would have the right not to testify, you would have the right to choose whether to testify or not. You have the right to call witnesses and present evidence, including asking the court to subpoena witnesses, to issue subpoenas for witnesses and documents. At any trial, you would have the right to confront witnesses called by the district attorney who may testify against you and ask questions of those witnesses. And finally, if you went to trial and you were convicted, you would have the right to appeal that conviction to a higher court. Do you understand those rights?
Yeah.
Do you understand that by pleading guilty, you're giving up these rights?
Yes.
Do you have a question?
No.
Okay. Do you understand that there will be no trial in this case,
Yes. I
given your
understand.
plea, your guilty plea?
I understand.
Okay. Now, I have in front of me what's called, it's a Rule 11 guilty plea advisement. Did you have a chance to review it all?
Yes. Yeah.
I see that there were initials on each numbered paragraphs. Are those your initials?
Yeah.
And on the last page of the document, there's a signature. Is that your signature?
Yes.
By reading, by initialing and signing this document, this Rule 11 guilty plea advisement, does that mean that you read and you understood the document and what you were signing?
Yes.
And did you have enough time to review it?
Yeah.
Okay. I also have in front of me a document that's entitled Elements. It says Elements, attempted second-degree kidnapping, seize, carry victim, a class 5 felony, and the statute. I see that there's a signature on the back page. Do you see
Yes.
that?
Yeah.
Is that your signature?
Yeah.
And does that signature indicate that you read and you understood it and that you had enough time to review and understand it?
Yeah.
Okay. Now, in signing these documents, do you understand that you're giving up any defense that you may have to those charges?
Yeah.
Okay. And that you're subject to the penalties provided by law for committing the offense?
Yeah.
I'm sorry.
Yes.
Okay. Now, I want to explain to you what the possible penalties for the offense are in this case. So you are pleading to count 3, attempted kidnapping, which is a class 5 felony. You're facing between 1 year and 3 years of with the Department of Corrections, between $1,000 fine and $100,000 fine, and a mandatory period of parole of 2 years. Do you understand that?
That's it. Just DOC.
Yo, that's
I was-
exactly what I was thinking, Judge. What? 1 to 3 years? That's it? That's what he's pleading guilty to? A crime that's 1 to 3 years because they knocked it down to attempted. Because he has all those other crimes. If he pleads guilty to attempted here, he can wrap it all up. 1 to 3 years.
Under the sentence, open sentencing.
Sentencing shall be open to the court,
Yes.
but the possible penalties
Yeah.
for this offense, that's what I'm reading
Yeah.
for you.
Well, I
So
understand.
that's,
I
okay?
understand.
Yeah, so it's open to the court, so you can get other things, but that's what you're facing per statute, okay?
Okay.
All right. Do you have any questions about that?
Question.
All right. And this wasn't, there's no extraordinary circumstances associated with this, right?
Your Honor, none that I'm aware of for this Denver case, no.
All right, okay.
Denver, nailed it.
Having heard that, and the disposition that we've discussed, has there been any other promises made to you to get you to enter into this guilty plea?
They didn't promise to cook you steak every day for the rest of your life and wash your car and pay your electric bill too?
Into this plea?
No, none
No?
other than me being able to speak with the other counties, no.
Okay, speak up, because I'm recording everything you're saying, so.
Oh, no, none other than being able to speak with the other counties about the plea. And also
Nothing
the
except for
concurrent
being able to
aspect.
go to the other
No.
counties and.
That's it.
Okay. And is anyone forcing you or pressuring you in any way to get you to plead guilty?
No.
Okay.
The good news is, there is good news of this, okay? What what he agreed to is if he pleads guilty in all the counties, right? All the sentences have to be concurrent. Not all the sentences have to be less than this sentence. All the sentences have to be concurrent. So I think, so if he goes to Adams County and pleads guilty there to bribery and gets 8 years, he's going to get 8 years. Like, he's going to get the biggest one out of all of them.
Is your decision to plead guilty your own free and voluntary decision?
Yes.
Do you want to talk to an attorney about the plea, or are you good moving forward on your own?
No.
Okay, you're good with moving forward on your own?
Yeah.
Okay. Now, there is, usually I would ask an attorney whether or not.
Of course he's good going forward on his own. I want him to be my lawyer. Shit, look what he did. Look what this man did for himself.
They would waive or stipulate to a factual basis, but why don't you tell me what it is that that happened that led to this guilty plea?
That led to the guilty plea.
Yes.
Your Honor, I'm happy to put the brief factual record on if the court would.
Okay, why don't you put it on and then I'll ask Mr. Robinson whether or not that's what happened.
And Your Honor, if Mr. Robinson, just very briefly, if we did not accept this plea and we went to trial on the 2 original counts, what my office would be seeking evidence to prove is that on September 23rd of 2024, that the defendant and another person encountered the 2 named victims at a store on Colfax here in Denver, that the victims were forced inside the male victim's car, and through threats by the defendant in front of the court today and the co-defendant, the victims were made to drive to another location in Aurora and were able to escape from the car and call police in Aurora. And so that would be the basis of our kidnapping charge for both victims. Obviously, we're pleading to the attempted kidnapping as part of the plea, but that would have been the evidence that we admitted at trial.
Okay, thank you. Is Mr. Robinson, is that what happened?
That's my now.
I feel like she should be prosecuted. I feel like she should be prosecuted for a crime for dropping that down to attempted kidnapping. But I don't know all the details. I only know a tiny bit of the details. So maybe the victims refuse to speak. Maybe the camera angle is so bad. Maybe the other guy has an ironclad alibi that breaks her evidence up. I don't know. But it's all right. I said I wasn't going to get mad.
That's my understanding of what they claimed. Yes.
Okay, and that's what they're indicating that they would have to prove had they gone forward to trial and that you had not accepted this plea, okay?
Yes, I understand.
All right, you understand that?
Yeah.
Okay. Do you understand that if you're, do you agree with that recitation?
No, I was there. No, but it's all right. That's what they claim. That's what they claim.
Okay, and having heard what they would have to prove had they gone to trial, are you still in agreement with accepting this plea?
Yeah.
Okay. And do you understand that if you're not a citizen of the United States, there may be immigration consequences associated with your plea?
Yep.
Okay. Do you still want to plead guilty?
Yes.
Okay. The court will tentatively accept the plea, your plea of guilty. The court will make written findings accepting your plea, noting that it was knowingly, intelligently, and voluntarily accepted. The judgment of conviction will enter as to count, count 3. Counts 1 and 2 will be dismissed. Is either party requesting a PSI?
Your Honor, I think it makes sense to get a PSI based on the number of counties and the fact that this is an open sentence. I will also just put on the record, we are VRA compliant for the plea today. I also understand it's a pro se plea. I just want to also put on the record, I have been in communication with Jefferson County, where Mr. Robinson is also pro se, and Adams County, where he's represented with the DAs there, as well as his counsel in Adams County, so that everyone is versed on the plea, the global, what we're doing to hear, all of that. So my understanding right now is that all parties are in agreement. I understand that Mr. Robinson is not represented. I just want that communication to be clear. But I do think a PSI is appropriate.
Okay. You know what a PSI is, Mr.
Yes.
Robinson?
Yes.
So I'm gonna,
Pre-sentence investigation.
yeah, it's a pre-sentence investigation report.
Yeah.
So the probation department is gonna compile all information about
Yeah.
you, your background, what happened here. They're gonna do a little bit of testing to see what your, kind of like your level is for possibly reoffending. And then they'll prepare the report. And then they'll see.
No PSI needed. He's most likely going to reoffend because he never got in trouble for doing it to begin with.
They'll make they'll just tell me what it is that you're eligible for, and then I'll make the final decision as to what your sentence should be, okay?
Okay.
All right, do you have any questions about that?
No.
Okay. Now, because you are in custody, it's gonna take a little while. So I am going to schedule this. April 6th. April 6th at 8:30.
That works for the people.
April 6th at 8:30. Does that work for you, Mr. Robinson? I mean, that's kind of a weird question, but I'm still gonna ask you.
It's fine.
It's fine?
That's fine.
Okay, do
I
you
don't-
know when
there's
your
nothing
other
else set.
cases are?
Yeah, but I think those dates are the 18th and the 19th.
Of
So,
February?
yes.
Okay. All right. So they're likely to look at our PSI and kind of like figure out what's going on with ours and rely on ours anyway. So
Yeah.
whichever one is done first. So I'm going to set you for April 6th at 8:30. All right.
All right.
So I will see you then.
I did not get all of Adams and all of Arapahoe today. Or was it Jefferson? Or was it all three? To see if I could get this guy. I forgot about it. But tomorrow I can get all of Adams, all of Jefferson, all of Arapahoe to see if I can get this guy.
Thank you.
Good luck to you, sir. But I'll see you on April 6th.
And Your Honor, I did file that motion to add count 3, so that should get to the court sometime today.
Whatever.
And to dismiss
You shut
counts
up.
1 and 2.
Oh, dismiss counts 1 and 2 at sentencing.
Okay. All right. Perfect.
Thank you, Your Honor.
All right. Thank you.
Okay. All right. Let's get out of here. Let's get out of here. I think we're gonna go here. Come on, please play. There's no reason for you to not play.
Did the court receive the letters of support I emailed this morning?
Wait, that's the one we just did, right?
No? Okay.
Yeah.
Proving all the elements
He
of the
got me
charges
so
beyond
mad. I
a
picked the
reasonable
wrong
doubt
one.
to all 12 jurors because any jury verdict must be unanimous.
And then, Your Honor, we have Mr. King, 2 matters.
All right. Let me resize. Let me reevaluate my life choices. We're still in Colorado. I'm just going to leave it that big because there's nothing else going on, I don't think. If we see something happening, I'll make it smaller again, but we can't really see anything when it's one little square. All right, now I made it. It's just too big. How's that?
Oh, did we lose Steve?
Oh, I'm handling it.
Okay.
Do we have a disposition?
Your Honor, we are going to proceed with the disposition that the court did go through last time. So the paperwork should all still be in the file. If the court remembers last time, we had gone through the disposition and then it was in sentencing when we had discovered that I had misadvised Mr. King. After going through that, Mr. King would like to proceed with the agreements that we had come to before.
Okay. The paperwork is not uploaded.
I will just re-forward the email, I suppose.
I actually don't know where Lafayette went. Probably got scared because I got mad at that other guy. Mad. He ran. He's totally scared of me. I'm in charge of this house, not the cats.
And sorry, Your Honor, I just assumed it was in the file since we went through it last time. I forwarded the court a copy of it.
Okay.
You don't know. It could be true. Could be true. You don't know. I can prove that my cat is terrified of me.
All right, Mr. King, to go over this
Hold on.
again.
Judge, this is very important. I'm about to prove a point. Okay. Even if I call him, he won't come to me because he's terrified of me. Lafayette, come here. Lafayette, see? Terrified of me. He will not come to me if I call him. That's how scared he.
Plea agreement states that you would plead guilty to count 2 in the aggravated range. Distribution of a controlled substance, a class 4 drug felony. In exchange, the people will dismiss count 1, and the stipulation is to a year in the Department of Corrections concurrent with 21 CR 2293. Is that?
Okay, just for the record, never in my life has the cat ever come to me when I called him. Ever. Like when I call him, he specifically does not come to me ever. I have to sort of ignore him and pretend I don't need him for him to actually come to me. And that's for him to come to me right now is just bull.
Your understanding of the agreement?
Yes, ma'am.
And is this how you'd like to proceed today?
Yes, ma'am.
And you've discussed this with your attorney?
Yes, ma'am.
You're satisfied with his representation?
I am.
All right. Tell me your full name again.
Malik Lumumba King.
And are you the defendant charged in this case?
Excuse me?
I'm sorry, are you the defendant charged in this case?
Yes, ma'am.
How old are you?
I'm 52.
How far have you gone through school?
I have my GED.
Do you read, speak, and understand the English language?
I do.
You're thinking clearly today?
Yes, ma'am.
Have you consumed any prescription medications, drugs, or alcohol in the last 24 hours?
No, ma'am.
Any mental or emotional condition that would make it difficult for you to understand what's happening today?
No, ma'am.
Are you a member of the United States Armed Forces or a veteran?
No, ma'am.
Have you ever served?
No.
Okay. This is an added count, is that right?
Yes, I believe so.
I don't have that. Can you read the added count? Did the people have it?
I apologize. I also was under the impression that the paperwork had been filed already, but I can locate it.
I included you on the email if you want to pull up the elements.
Count 2, distribution of a controlled substance. On May 26th, 2022, Malik King unlawfully, feloniously, and knowingly sold or distributed morpholine, a Schedule 3 or 4 controlled substance in violation of Section 18-4051 2DI.
With respect to that count, sir, do you plead guilty or not guilty?
I'll plead guilty, ma'am.
All right, I need to make sure you understand your rights before I accept your plea. You have the right to be represented by an attorney at all stages of a criminal proceeding. So not just this proceeding today, but all proceedings, including a trial. If you're indigent and you can't afford an attorney, one would be appointed to you at no cost. You also have the right to a speedy and public trial that must be held within 6 months of the entry of your not guilty plea. And you have the right to have these charges proven against you before you can be convicted of them. So at trial, you'd be presumed innocent. You would not have to prove anything. The district attorney would have to prove your guilt by proving all of the elements of the crime charged beyond a reasonable doubt to all 12 jurors, because any verdict must be unanimous. At trial, you would have personal rights, including the right to testify and the right to not testify. And that decision whether or not to testify would be your decision. You would have the right to call witnesses and present evidence, including asking this court to issue subpoenas for witnesses and documents. And you would have the right to confront any witnesses called by the DA who may testify against you and ask questions of those witnesses. If you did go to trial and you were convicted, you'd have the right to appeal to a higher court. Do you understand these rights?
Yes, ma'am.
And do you understand by pleading guilty, you're giving up these rights?
Yes, ma'am.
And you understand there will be no trial given this plea?
Yes, ma'am.
And I have the paperwork that's been provided to the court that goes over this plea agreement as well as your rights. It has the initials MK throughout the document and a signature above your name in electronic format. Did you permit Mr. Goldstein to initial and sign this for you?
Yes, I did.
There's also a document that goes over the elements of the charge you're pleading guilty to. These are the elements the DA would have to prove at trial. Did you permit your attorney to sign this on your behalf also?
Yes, I did.
By initialing and signing these documents, does that mean you've read them, understood them, and had an opportunity to ask him questions about them?
I haven't, I did.
You have had that? And in signing these documents, you understand you're giving up any defense you have to the charges?
Yes, ma'am.
And you understand you're subjecting yourself to the penalties provided by law for the offense you're pleading guilty to?
Yes, ma'am.
And the possible penalty here is in the aggravated range of 9 months to 2 years in the Department of Corrections with 1 year of mandatory parole and a $1,000 to a $100,000 fine. Has your attorney advised you, if you're not a United States citizen, that immigration issues could arise from a guilty plea?
Yes, ma'am.
Other than this agreement we've discussed, has there been any other promise made to get you to plead guilty?
No, ma'am.
Anyone forcing you or pressuring you in any way?
No, ma'am.
Is it your own free and voluntary decision
Yes, it
and
is.
factual basis?
We would waive.
All right, you still wish to plead guilty?
Yes, I do.
Do you have any questions at all about any of this?
No, ma'am.
I'll find your plea is knowing, voluntary, and intelligently entered. Judgment of conviction enters on added count 2. Count 1 is dismissed. And Mr. Goldstein, we can move to immediate sentencing. And why don't you just include based on that plea, your probation is automatically revoked on that new law violation. So if you could just proceed on sentencing on both.
Yes, Your Honor. And I did make an argument last time, but I will just briefly repeat that. First, I would note for credit, Your Honor, he has 181 days on 22 CR 2894. And he has 505 days on 21 CR 2293. We do appreciate these agreements as these are very old. These, I think, are designed to help him, move past this. He will be on a parole term, likely pretty quickly with these offenses. At the time, he had gotten released on probation. When the second case was picked up, as far as I understand the allegations, he was, living on the street. He was outside of a tent with his shirt off. It was a controlled buy for $20. Certainly affects the community, but also he was going through stuff at that time, and I think he is in a better place now. So in terms of that, Your Honor, we are asking the court to consider just on the revocation, sentencing him to the minimum of 2.5 years with the 505 credit. That way he can hopefully get started on this parole term as quick as he can and really just work on getting this portion of his life put behind him.
What's the people's position?
Your Honor, on the revocation, I am asking for 4 years. We had at the last court date stated that we would not ask for more than 4 years based on the confusion with the advisements. In the 21 CR case, he never reported to probation after he was sentenced. He pled to a class 5 felony attempted assault in the second degree causing SBI. In that case, the allegations are that he went to the victim's home and unprompted began to assault her. He strangled her until she urinated herself. He threatened her with a knife, and then he held her for over an hour while he continued to assault her repeatedly in the face, neck, head, and back with approximately 20 blows. At the time of that offense, he was on probation for possession of a weapon by a previous offender. When the assault was reported, the victim indicated that he had been abusing her for the past 3 years. Probation is a privilege. You cannot simply opt out, and you cannot simply decide to not show up because it's inconvenient. especially when you have pled to a crime of violence. Domestic violence is a particularly difficult crime to prosecute and difficult crime for the court to handle because it's different from other crimes in that a criminal history doesn't reflect the depth of domestic violence. And domestic violence, we see a snapshot of a relationship, but we don't ever see the full picture. His criminal history doesn't reflect that he had been abusing her for 3 years. And there are many reasons for that. But he has demonstrated that he's a community safety risk, and he's demonstrated that he's not interested in community-based treatment or supervision. He was never even assigned a probation officer because, like I said, he never reported. Because this is a revocation and a resentencing, I would ask the court to consider giving as little of credit as possible on this case. That is within the court's discretion, especially the pre-sentence confinement credit that was when he was in custody the first time that this case came around. That is certainly within the court's discretion. And I would submit to the court that that is appropriate given his refusal to participate in probation and the severity of this offense.
All right, Mr. King, you don't have to make a statement, but you have the right to if there's anything you'd like to say.
Yeah, first I'd like to apologize for not showing up to probation. That was like one of the worst mistakes I've made in a long time. But since then, I've been in the treatment. I went and got my housing. I was in the Red Cross the mayor's program. I did over a year in that program. Within that year, I tried to get back in the court, and I had the paperwork. I think that they sent to you saying that I went to the homeless court. There was no record of my warrant, and then I went to the warrant forgiveness. So I looked at it, and by the way, I don't. Besides my child, I don't met me and the girl. We don't converse or nothing. You know, it's over. I was on drugs. I was heavily on drugs at that point in time in my life. A lot of things I don't even remember doing around that time, and I'm not asking for excuse because I don't like that man that I was, and I have took points to try to like deal with my anger. First off, I'm not on drugs no longer, and I just I'm just trying to get this over with. Since then, I was staying in a tent. I have my own apartment. And I have the people waiting that's gonna hold it for me for a little time, but they are giving me time to like get my life in order. And I just like to apologize because I should have tried to go to probation and try to like make something of it with the structure that they was giving me. But without it, it took a little time. But I did take a step forth and enter myself into programs to try to help myself, and that's it.
Okay, thank you, Mr. King. You certainly look better than you did in your arrest photo.
Yes.
These domestic violence cases, though, especially strangulation, are very concerning. And when you haven't received any treatment, I don't feel confident that, you'd be any safer in the community until you've received appropriate domestic violence treatment. when I look at these cases and consider the sentencing factors on the disposition in 2894, I'm going to accept that agreement and sentence you to 1 year in the Department of Corrections. It would be 1 year of parole. You have 181 days credit. That's concurrent to 21 CR 2293. When I consider the seriousness of this offense and the fact that probation was never attempted, there hasn't been significant progress there. I will sentence you to 4 years in the Department of Corrections. I will give you the 505 days of credit. That is 2 years of mandatory parole. Do you have any minor kids in Colorado?
Yes, I do.
Are they subject to the dependency court for dependency and neglect?
No, we I think we're over that.
Like a Department of Human Services case, there's none of that, right?
No.
Okay. Since you're going to be in custody and you've been in custody for a while, it sounds like you were experiencing homelessness also. I'm going to waive your waivable fees and costs with the exception of the victim's assistance and victim's compensation fees. For the 21 CR 2293, that protection order will remain in place throughout the pendency of your sentence. Are there any amendments or issues with the protection order?
No, Your Honor.
So you do need to not harass, molest, intimidate, retaliate against, or tamper with any witness or the victim. You have to vacate the home of the victim, stay away from her home, and stay away from any other location where she's likely to be found. You can't have any direct or indirect contact with the victim. You can't possess, purchase, or control a firearm or other weapon. You can't possess or purchase ammunition. And you have to relinquish any firearm if that hasn't already been done. You can't possess or consume alcoholic beverages or controlled substances. And you have to remain 100 yards from the victim at all times. If I didn't say the waivable fees and costs, I think I did. Anything else? And these cases are concurrent to each other. Are there any open cases? I saw that there was some significant criminal history, but any open cases that this needs to run concurrent to?
I don't believe so.
I don't believe so.
Okay. All right. Okay. All right. Good luck to you, Mr. King.
I would love to give you guys more cases where they got the actual jail time they deserved for the crime they committed. I really would. It would be my pleasure to present those cases to you, but there really aren't any. I mean, it would be nice for us to say in chat, oh man, that's too many years. That judge was harsh. Oh man. That would be a lovely chat session, wouldn't it? What? He got 40 years for shoplifting a sandwich? No way. That would be a night to remember. But there aren't any. There just aren't. But, yeah, be wealthy. Have a good night. Sleep tight. That's what I have for tonight. But don't worry, we're going to do it all again in a couple hours. Behave. Be good tonight, okay? Go to sleep. Miss the morning stream because you're sleeping too much. Do that. Make sure you do that. All right? Thank you for coming out. I really, really, really appreciate it. I hope that you guys have a great night, and I'll see you very soon. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. and see